rise for the jury.
Good morning. Take your seats, please. All right, again, thank you for coming back. I began your orientation yesterday in terms of rules that you are to follow. Again, let me repeat these. No lack of clarity. During recesses and adjournments while this case is in progress, you should not discuss the case with other jurors or with anyone else. Should anyone attempt to have a discussion with you, now I'm talking the entire duration of the trial, you are to inform that individual that you are a member of the jury and you cannot discuss any aspect of this case with them. If they were to persist, you're to immediately report that to either the bailiff or directly to the court. You should not form an opinion or express an opinion as to any issue in this case until you've heard all of the evidence, the instructions of the court, and the closing arguments of the attorneys. This is a criminal case that was commenced by the state against the defendant, Tai Chan, who has been charged with first-degree murder, willful and deliberate. The defendant is pled not guilty and is presumed to be innocent. The state has the burden of proving the guilt of Mr. Chan beyond a reasonable doubt. And what I say now is an introduction to the trial of this case. A criminal trial generally begins with the attorneys telling you what they expect the evidence to show. Then the evidence will be presented to you. The evidence will be the testimony of the witnesses, exhibits, and any facts that are agreed to between the court and the attorneys. After you have heard all of the evidence, I will instruct you on the law. The attorneys will argue the case, and then you will retire to the jury room to arrive at a verdict. It's important that you understand that each one of you is going to be asked to make an individual decision in this case as part of a collective process. You have to maintain your focus throughout these proceedings. You can't daydream, you can't think of other things that you'd rather be doing. You have to be completely focused on what is occurring. When the attorneys in a few minutes begin their opening statement to you, please remember, it's not evidence. It is what they expect the evidence to be in terms of the presentation of their cases. The evidence so that it's very clear to you. The evidence is the testimony from the witnesses from this witness chair and any exhibits that will be admitted into evidence. And there will be many exhibits admitted into evidence. And there will be a substantial number of witnesses. That is the evidence. So, after the evidence is presented, then I will review with you, or I will give you, the instructions that you have taken an oath to follow in terms of how you will arrive at a verdict. After I have done that, the attorneys will argue the case. So you really can't lose your focus and think that, well, at the end of the case, the attorneys will just give me an executive summary of what the evidence was that was presented, because that's what they do in their closing statements. They discuss the instructions that I will have just given you. and they will discuss the evidence that has been presented. But what they tell you in their closing statements or their closing arguments to you is not evidence. You have already heard all of the evidence. So that's why it's so important that you maintain your focus throughout the entirety of the proceedings. Your purpose as jurors is to find and determine the facts in this case from the evidence. It is my duty to decide what the evidence that will be admitted for your consideration, contrary to anything that you've ever heard. This is a very transparent process. But there are rules of evidence that we must follow, and these rules of evidence have been developed over hundreds of years to bring us to where we are today. What is their purpose? To ensure to the greatest degree possible a fair and impartial outcome in this trial. So, and I think it was alluded to in the voir dire examination, the attorneys throughout the course of this trial will be making objections. You've seen it enough on television, although it's never properly depicted. They will make objections. What are they making objections to? Well, they're going to object to the question that is being asked by the other attorney of the witness. Why? Because they believe that the response or information that would be provided to the jury would be inappropriate for the jury to consider. So they'll make an objection. They may make an objection to an exhibit because, again, they do not believe that it would be appropriate for you to consider that evidence. These rules of evidence are there to make sure that you are being given relevant, pertinent, and important information related to the issues in this trial, but not to provide you with information that isn't really applicable, that isn't relevant to these proceedings. So you're not to speculate, well, why is the judge not letting us hear the answer to that particular question? Why? Because it wouldn't be appropriate for you to consider it as evidence. Anything that is testified, anything that is said to you is evidence, but it must be appropriate evidence for you to consider. So if I sustain an objection, and I'm sure you've heard that on television as well, that's when the judge maybe is paying attention. They don't ever depict the judges that well on television, but the judges normally pay a lot of attention to what's going on. So if I sustain an objection, that means that I agree with the attorney that is making the objection that it is not appropriate for you to hear the evidence or to consider the exhibit. And so if there is a partial response, say that the objection was a little bit late and there was a partial response, you are to disregard completely as evidence whatever you may have heard if I sustain an objection. If I overrule an objection, I don't agree with the attorney, and I believe that it is appropriate for the response to be given to you or for the exhibit to be admitted for your consideration as evidence. Again, don't speculate. We're doing it in order to ensure to the greatest degree possible a fair and impartial outcome in this trial. You must decide the case solely upon the evidence received here in court. You must not consider anything that you may have heard or read about the case outside of the courtroom. During the trial and your deliberations, you must avoid news accounts of the trial, whether they be on radio or television or in the newspaper or any other written publication. You must not visit the scene of the incident other than there will be a visit to the hotel encountered by the jury this afternoon. That is the only time. You cannot go back later. You cannot go back before in order to look at the scene. Let me stress to you so that it is clear, because sometimes there is a bit of confusion. You're not here to investigate anything. That isn't the role of the jury. You are neutral observers of the presentation of the evidence. You don't do anything. You don't experiment. You don't check up on anything. You don't get on the computer to look for additional information. If that were to occur, and it was brought to the attention of the court that you had relied on anything outside of the presentation of the evidence in this courtroom, I would, at a minimum, have to dismiss you as a juror, and potentially we would risk a mistrial, which means that all of the work that we would have done up to that point would have gone for naught. So be very understanding and respectful of the role that you have, which is to listen to evidence that will be presented and to answer the question as to whether the state has proven the guilt of the defendant beyond a reasonable doubt. You are neutral as to that question. There is a presumption of innocence until the proof has been achieved. Ordinarily, the attorneys, and just so that you understand, the presentation of the exhibits, that's why you have these little screens here in front of you. We don't have a big screen that comes down as we do in the other courtrooms, so you will see the presentation of the exhibits when they are published to you on these screens right in front of you. Ordinarily, the attorneys will develop all of the pertinent evidence. It's the exception rather than the rule that an individual juror will find themselves with a question unanswered after the testimony is presented. However, you see that all of you have notepads, and I think it's important in this trial, because of the length of it and the number of witnesses, that you keep some notes. You certainly can judge how good your memory is and to what degree you have to make notes. But let me caution you, don't be and I say this respectfully, don't be a serial note taker. Don't be keeping your head down and just writing notes throughout the course of the trial, because some of us do that. We get it from when we were in school. Just sit there and listen to the professor or teacher lecture, and all we're doing is writing notes furiously. Okay? Every witness that will testify, you will have to assign a level of credibility to that witness. You can't do that if your head is down all the time and you're never observing the witness. Part of the reason for the notepads is because at the end of the questioning by the attorneys of each witness, I will turn to you and ask you, does the jury have any questions of this witness? We permit the jury to ask questions of the witnesses, but there's a special format for how we do it. Let me also suggest to you, at least in 90% of the cases that I've been involved with, questions from the jury have enhanced the quality of the evidence that is being presented. Many times, jurors have been able to ask questions that were actually overlooked by the attorneys, and it contributed substantially to the process. So I'm going to ask you, if any of you, if the jury has questions, you don't have to stand up, you don't have to say anything, all you have to do is just signal me that you're going to have a question. The way the jury asks questions in this process is that you will write out the questions that you have. Don't start writing them out at the beginning of the questioning of the witnesses. Wait, listen to the questions that the attorneys are asking, because the question that you might have will be covered by the attorney's questions. It is at the end of their questioning that you will write out a question if you feel that you need an answer that wasn't asked during the course of the attorney's questioning. doesn't have to be limited to one. You can ask as many questions as you would like. You are not asking the court a question. You're not making a comment to the court. You are asking a question to the witness. So it has to be in a question format. You have to sign the sheet of paper. You have to provide your juror number, not seat number, your juror number. You'll pass the page down to Mr. Narciso. He'll present it to the court. They'll review it with the attorneys. If it is an appropriate question, then the court will ask it on behalf of the jury. Do not hesitate to utilize that privilege that is being given to the jury. No statement, ruling, remark, or comment which I make during the course of the trial is intended to indicate my opinion as to how you should decide the case or to influence you in any way. If I do ask questions, and I really do try to limit, I am asking questions either on behalf of the jury or because I have become so confused by either the responses or the manner in which the question was asked that I'll be concerned that it may be confusing the jury. I may ask some questions, but only to clarify what the evidence is that is being presented to you. The prosecuting attorney, Mr. Mark D'Antonio, will proceed now with his opening statement to you, to be followed by Mr. Tom Clark, who will provide the opening statement on behalf of the defendant. Again, please be patient, listen carefully. This is what each party believes the evidence is going to be in this case, but please remember, it is not evidence. Mr. D'Antonio, if you will please proceed with your opening statement to the jury.
May it please the court?
Thank you.
Distinguished counsel. Good morning, ladies and gentlemen. The facts in this case will show that there is only one victim in this case. One and only one. That is Jeremy Martin. Let me take you back. The date is October 28th, 2014. The time, just about 20 minutes after midnight. The place, the 7th floor of the Acanto Hotel, right here in Las Cruces. All is quiet. Until the door from room 711 swings open and Santa Fe Deputy Sheriff Jeremy Martin bursts from the door. He is wearing only his pajamas and he has bare feet. Rapid gunfire rings out, described as pop, 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 pop. And before Deputy Martin fully exits the room, a bullet pulverizes his right tricep, while another bullet digs deep into his flesh in his back. He is unarmed. He is running for his life, and he is severely wounded. He turns to his left and runs down the hallway for the safety of the elevator doors, which are approximately 100 feet. That's the evidence will show you. The evidence will also show that at the same time, a local hotel security guard was on the 7th floor. He witnessed Jeremy Martin come out of room 711 holding his right arm. He also witnessed a subject also coming out of 711 stand in the hallway and begin to shoot at Jeremy Martin. Now, you'll hear that this guard was unarmed. He was frightened. He took a position of safety and called 911. As Deputy Martin was running away, the defendant, to my right, Mr. Tai Chan, a sheriff's deputy specially trained in the special weapons and tactics, voluntarily steps into the hall. He is fully dressed in street clothes and his stocking feet. He levels his semi-automatic Glock 57 loaded with 10 remaining hollow point bullets, takes aim at the fleeing Jerry Martin, and pulls the trigger 5 times. Witnesses will tell you what they heard was bang, 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 bang. Those shots were rhythmic, methodical, and accurate. 3 of those bullets tore through the flesh and organs of Jeremy Martin. A witness in a nearby room heard the shots and heard Deputy Martin cry out, "Oh God, why is this happening to me?" However, ladies and gentlemen, the evidence will also show that none of the witnesses heard anybody say, "Stop, freeze, don't move, police." No words of compassion or warning during the gunfire. Another witness will tell you that he was brave to open the door right after the shooting stopped. What he saw was a defendant walking down the hallway, gun in hand, headed toward the elevators. At that point, the witness slammed the door and took cover in the safety of his own room. The defendant then proceeds down the hallway to the stairwell. Let me be more accurate. Proceeds down the hallway to the elevators, makes a right-hand turn down another long hallway. At the end of the hallway, the defendant enters a stairwell. That stairwell leads up to a half-flight of stairs, which is a hatchway which leads to the roof. That hatchway was locked. It is in that hatchway stairway where the defendant, a man swore to protect and serve, hides until he's discovered by the police. 7 floors below, Deputy Hurd of the Las Cruces Police Department sees Jeremy Martin laying face down on the floor of the hotel lobby in a pool of blood just outside the elevator doors. She and her fellow officers do their best to put Mr. Martin on a homemade stretcher made of a tablecloth. They drag him outside, they put him into a waiting police car, and whisk him off to the nearest hospital. A short time later, Deputy Martin, 29 years old, is dead. Cause of death, multiple gunshot wounds, all fired from the defendant's handgun. All bullets struck Deputy Martin from the rear. All shots were fired from a distance greater than 2 feet. The evidence will also show that a team of officers led by 20-year veteran Todd Froats heads up the nearby stairway en route to the 7th floor. They have with them a trained police dog named Zero at their side. As they advance up the stairway, they announce their presence and ID themselves as law enforcement officers. The whole time, the dog Zero is barking. When the officers reach about the 6th or 7th floor, they hear a voice shouting, "Sheriff's Department, Sheriff's Department." The police attempt to identify the subject making those announcements. They learn that the subject is a law enforcement officer and he has a gun. The responding police officers issue commands to the subject. And the subject complies. The police instruct the subject to walk down the half-flight of stairs backwards with his hand interlaced behind his back. The subject complies without missing a step. The subject surrenders without incident on the 7th floor, just below the roof access. A partially loaded semi-automatic 57 is found nearby. The subject is identified as Tai Chan, badge number 7111. The defendant then addresses the police officers as his brothers and tells them that there's great danger in the hotel, and he warns them not to get hurt. He tells the police there's a bomb in the building, but won't say where. At the time of his capture, the defendant has blood on his nose, on the inside of his nose, and an injury to the inside of his lower lip. The police detect the odor of alcohol on his breath. While being detained in a police vehicle, defendant makes the following statements of many. He says there's a bomb on the 3rd floor. And then says, well, even if there isn't a bomb, there's danger. That he's been robbed and he's been set up. That he sees bodies floating past the car he's sitting in. He says he had to do it, but didn't say what or when. He also told the police officers, "Fuck you, you're not taking me seriously." Now, folks, you will learn what happened before that fateful night. 2 days earlier, Deputy Martin and the defendant were preparing to transport a prisoner from Santa Fe, New Mexico to Stafford, Arizona. They arrived at Stafford, dropped the prisoner off, and decided to spend the night in Las Cruces before heading home to Santa Fe. You will all learn that Officer Martin and the defendant worked together but were not friends. They arrived in Las Cruces, checked into one room at the Encanto Hotel, room 711, on October 27th, 2014. Later that night, they went out to have some dinner, have a few drinks, and watch Monday Night Football. You will hear that Defendant and Deputy Martin were not seeing eye to eye that night. And in fact, on 2 occasions, they separated. At about 11:30 or so, they returned back to the hotel after drinking in at least 3 different bars. And the defendant at that time was arguably drunk. There was a dispute in the room that night, as evidenced by some of the defendant's blood found on a bed nearest the door to room 711. Also, you had testimony of different witnesses who heard sounds, noises, and voices coming from the room that night. There is the evidence of a minor struggle. And you'll see pictures of the room that will display those evidence. However, the evidence will show without contradiction that the bed where Deputy Martin was going to sleep was turned down in preparation for sleep. The bed close to the door, which was assigned to the defendant, was fully made. An expert in crime scene construction will tell you that Deputy Martin never possessed a gun that night. Deputy Martin's 2 guns were locked safely in his suitcase or overnight bag in the corner. The evidence will show they were never used or fired. Five shell casings were found inside room 711. And evidence will show you today, and you'll be told, that a shell casing is the brass metal that's ejected from a firearm when a bullet is fired. 5 more shell casings were found in the hallway adjacent to room 711. 3 of those bullets struck Officer Martin in the hallway. The bullets burying themselves within his body. Total of 5 gunshot wounds were found in Officer Martin. The injury he suffered that night was direct cause of his death. You'll also hear, ladies and gentlemen, that Deputy Jerry Martin was a family man. He was married to his wife Sarah for 12 years. They had 3 children and 1 on the way. In fact, the evidence will show, ladies and gentlemen, that the main reason why Officer Martin shared a room with the defendant that night was to take that special assignment, which was an overtime assignment, by transporting the prisoner, which paid him extra money, the money he needed to support his growing family. The evidence will show that Deputy Martin was in constant communication with his wife that night, through texts and otherwise. Deputy Martin never returned home. The facts will show that the defendant repeatedly shot an unarmed, defenseless man in the back while he was running away from the conflict. Those are the facts. The defendant is guilty of first-degree murder, intentionally taking the life of Deputy Martin. Shooting an unarmed man in the back, as the facts will show, is not self-defense. And at the close of all the evidence, ladies and gentlemen, after your careful consideration of the facts and the law, I will come before you again, and based solely on the facts and the law, I will ask you to find the defendant guilty of first-degree murder. Thank you. Thank you, Your Honor.